Welcome once again to Lehto's Law. Here's Steve Lehto.
When I started my channel a few years ago, I never imagined I'd be talking about things like the Fourth Amendment and the open fields doctrine. I honestly thought that most people, if you ask them just, out of context, explain to me open fields, they'd be like, what? And then if you say, oh, it's the concept that the government doesn't need a search warrant to go into the open fields around your property. Or if you own a piece of property that's like wooded, that they can just wander through it anytime they want because it's not considered to be the same as like your home where you're guaranteed a right against intrusion under the Fourth Amendment. And many people have heard of that, but the interesting thing is I've talked about it on this channel before, and people are very interested in this topic because most people think that's wrong. But that idea goes back a ways. It's been around for a while. I remember reading about it in law school and reading cases in con law about the open fields doctrine, and thinking to myself, wait a second. So for my house, they need a search warrant. But for like the yard, they don't? What if I put up a privacy fence? That doesn't matter. They can fly over and look at you, And so a lot of people think this is wrong. This has been challenged in many states. And the Institute for Justice, for instance, is all over this one, especially in states where like the DNR or whatever you call your conservation officers, where they will come onto somebody's property and poke around and occasionally do things like, plant cameras to see what's happening on that property. To make, they'll say, well, we're investigating, make sure there's no illegal hunting going on or something. And there have been stories about people who've been on their own property and they see somebody running around out in the woods. They go out there and look, and it's a conservation officer. He's like, oh, I'm allowed to be here. Got a warrant? No. Open fields, even though it's forest. But open fields is just a nickname for the topic. Brian sent me a note, said, Steve, got an interesting story for you. You're here out of Michigan. And I said, Michigan? Now you got my attention. This is from a House representative in Lansing. So keep in mind that there's the federal government. You got Congress people, senators and representatives in Washington, D.C. State of Michigan has a very similar system. We've got a constitution that describes that we've got a governor, and then we've got the legislature, you got your House of Representatives, and you got your senators, okay? So a representative named Martin, that's his last name, has proposed a plan to require DNR officers to get a warrant or permission before entering private property. And he's proposing this as a law. So it's not going to be one of those things that the courts have to interpret and fight over. It's going to be, no, this is the law. So a state rep, David Martin, and the House Natural Resources and Tourism Committee this week approved two measures. These are House bills. Two measures strengthening private property rights and updating outdated enforcement practices within state agencies. Now, this is directly from a press release from David Martin's office. So you might think this is a little bit slanted for an article in a newspaper. But I think many people do think that the open fields doctrine is outdated. So these are House bills 4073 and 4421. They ensure that agents of the Department of Natural Resources and the Department of Environment, Great Lakes, and Energy, which is EGLE, are required to obtain a warrant or consent from the property owner before entering private property. The legislation also clarifies that the open fields doctrine does not apply to searches by these agencies. And so there's so many examples of things I can tell you. So imagine that you own a piece of property up north and you don't live on the property. Let's say you bought it for hunting purposes. You bought 40 acres out in the middle of nowhere. You go up there once in a while and you hunt. And you show up one week and there's clearly been activity on your property. Somebody walking around out there. Who was it? Well, it could be that it was somebody from the DNR just walking around without permission. And they could always say, well, it's open fields doctrine. So Martin said state agencies don't operate solely under the federal Constitution. They operate under Michigan's Constitution, which in fact offers even stronger protections for property owners. Our Constitution specifically protects not only people and homes, but also their possessions. That includes land. That means private property is not open territory for state agents to wander through without cause. The open fields doctrine came from federal cases involving alcohol stills during Prohibition, and then later illegal marijuana growers, not Michigan's wildlife environmental management practices. He said there's no reason for Michigan agencies to rely on a federal doctrine that weakens private property protections when our own Constitution already sets a higher bar. I did the video a week or two back about, I think it was in Maine, where they pointed out that in Maine, the Constitution there had much stronger protections regarding your right to an attorney than the federal Constitution as interpreted by the U.S. Supreme Court. And so the Constitution offering you better protection, you can rely on it and you get a slightly different result. And here, Representative Martin is saying the same thing. He's going, look, you can talk about the federal open fields doctrine from the Supreme Court of the United States all day long, but Michigan has a constitution that talks about your rights here. So he also said just because most private property lies outside a home's immediate area doesn't mean it's free and open for state agents to intrude upon you. And he, by the way, is the chair of the Natural Resources Committee. If a conservation officer or an Eagle inspector suspects criminal activity, they can do what every other law enforcement agency in Michigan does: go get a warrant. That's how we preserve constitutional rights and maintain public trust. The legislation includes common sense exceptions, allowing officers, for instance, to enter without a warrant when they have permission, if they're in hot pursuit of a suspect, or if they need to protect life or property, or they are witnessing a crime, or must act to preserve evidence. And those exceptions are usually pretty common, okay, even in other settings. But obviously, if they see somebody run onto property and they're chasing them, they can't, they are on private property, we can't chase them now. But the key here is we're talking about them coming out and just wandering around your property looking for stuff. So he said, these updates don't weaken conservation or environmental enforcement. They simply bring them in line with constitutional standards. We can protect natural resources while still respecting the fundamental rights of Michigan property owners. Both measures now move to the full House for further consideration. So we don't know what's going to happen. You remember what happened to Bill up on Capitol Hill, right? So you know how this goes. So these are proposed. They're going to go to a committee. The committee is going to look at them and possibly tweak them a little bit, and then pass, take a vote on whether it should pass out to the whole legislature. And if it passes that, then somewhere it'll get read to the legislature. They read it a couple of times, and finally they ask for a vote. And if it passes that vote, then it gets sent over to the Senate. The Senate looks at it, submits it to their committee, who goes through it and does what they do. And, of course, they eventually send it back out to the Senate for a vote. And if it gets changed in that process, remember, then it's got to go back to the House, and they may have to have a reconciliation where the two houses send teams in to try to come up with a version they can both agree on, and then they pass it. And if it passes all of that muster, then it gets sent to the governor's desk for a potential signature. And so there's a whole process here. We're very early in the process. But one of the things I can tell you is that quite often, all kinds of laws get proposed along the way. Some get passed, some don't. A lot of them just disappear. And I've actually seen laws that get proposed and they die, proposed and they die, and they just don't make it all the way through that process. But a law like this, I think it's important, especially because I'm glad that Brian sent me this, because I got word of this early enough where I can talk about it and say, this is a great idea. And so if you're in Michigan, you might want to consider calling your rep or your senator in Lansing and telling them about this and saying, I am in favor of this. And I've known so many people, friends, relatives, and clients. Did you think I was going to say countrymen? No. Friends, relatives, and clients who own property that's more than just the yard around their house. Whether it's vacant land someplace, or they've got a cabin, or they've got a camp. They sometimes call it a camp. Or they've got hunting property. And the number of people I've met who are concerned about this is quite large. And the number of people I know who've said, I've had issues where I've found that someone was on my property and I later found out it was somebody from the state just out traipsing around. And, one of the things that I encounter from time to time is people say, Steve, if you're not doing anything wrong, do you need to be worried about the government? I'm sorry. I was going to try to say that without laughing. But there are people out there who actually think that. If you're not doing anything wrong, why would you care? Number one, because I don't have to let them do that. One of the things about property ownership is that you have the right to invite people onto your property and to exclude others from your property. And if you look up what rights do I have as a property owner in the law, it'll almost always say that. You have the right to invite people on and exclude people. You have that right. You don't have to. And so when somebody says, can I come out and just snoop around your property? No. How does no sound? No. I don't want you snooping on my property. And I find it creepy, but there is a concern that many people have that when somebody shows up from the government and they want to snoop around your property and they don't have any probable cause, they don't have a warrant, they don't even have enough to go get a warrant. They're just curious. They're nosy. They're poking around looking for something. And a concern a lot of people have is that I'm not doing anything wrong, but my concern is if somebody's out there poking around looking for something, it's not necessarily going to find it, but it just bothers me. Can I look in this? Can I look in that? Hey, what do you got in that? I got an idea for you. Get off my property. How's that? And so I know that some people might think, Steve, you sound unfriendly. I've had people on my property. I've invited people onto my property. But somebody wanders in and says, oh, by the way, I'm from the government. Perhaps you should leave my property because I have the right to exclude you, along with anybody else I want to exclude, from my property as a property owner. I hope this bill passes. So again, it's Representative David Martin proposing two House bills, 4073 and 4421, and that would, in essence, eliminate the open fields doctrine when it comes to state agencies within the state of Michigan. So there you go, Brian. Thanks for sending that. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If I could just say a few words, I'd be a better public speaker.